Morning, Maurne. Good.
Morning, Gavin. Good to you.
Lovely. Nice catching up again. As everyone knows, you and I have been in the trenches, the legal trenches before. And I think with our involvement with Funda and still in the industry, we bounce a lot off one another.
Yeah, I know.
So I think it's these talks we do for the benefit, obviously, of our target audience, being our plaintiff attorneys, and then obviously our experts as well.
Yeah.
And I think it's important to keep the quality of the product and what we're delivering to the industry, what Funda is delivering to the industry. I think it's important that we discuss these things.
Yeah.
So I thought it good. Let's have a bit of a discussion around the latest judgment. I'm quite excited about that. You know which one?
Undertaking one. The one of the undertaking, yeah. The conditional injury-specific undertakings.
Yes.
Yeah.
So just for the benefit of those listening in and that are not involved, that are not attorneys, Section 17(4)(a)(1), paragraph 1, specifically states that when the Road Accident Fund issues an undertaking, it has to be unconditional. They can't limit it. So if, for example, the expert now, let's say the expert, the orthopedic surgeon, for example, prescribes the following treatment for the future, they would say that's covered under the undertaking, but it doesn't mean that that's specific. So say it's 10 sessions of physio and a knee replacement or whatever the case might be. They don't specify that as such. They use that as a guide because you may or you may not use it. So there can be no caveats attached to that. So the RAF, in their infinite wisdom, at one stage under the leadership of the now previous CEO, came up with a basket of care. When you remember receiving them?
Yeah, no, we received a few of them, and I mean, it was actually, when you're looking at the undertaking, there's so many conditions that they've placed in those undertakings. I mean, as far as the Act is concerned, there's no conditions. The only condition is that it should be treatment that's already been incurred, and obviously the cost has already been incurred, and there should be a nexus between the treatment and the accident, the injuries that were sustained in the accident. So that's the only conditions that's in the Act.
Well, obviously, I mean, let's just unpack this now quickly. So what they say is we don't mind paying,
yeah,
but we want to specify what we want to pay for.
Yes.
So I think the court was quite graphic in that, in saying you expect the court to, for use of my own words now, to look into the proverbial crystal ball and condone what you're saying, that you're only going to cover X amount of physio sessions or this treatment or whatever. Whereas it should be, I mean, every person, accident victim, will respond differently.
Yeah.
So you can't label that, place that caveat and say you'll only be covered for this and this and that. So I think it was obviously, we know the judgment, it was ill-founded, it was ill-brought judgment, application, and I think the court was quite clear in their disdain about it.
Yeah.
I think the knock-on effect that we need to discuss is how does that impact the attorneys, first of all. So it's important, I think, number one, attorneys do not accept the basket of care.
Yeah.
If you've accepted the basket of care, and you and I, we had a bit of a discussion about it, what happens with those basket of care undertakings that have been accepted now that this judgment has come out? Do they automatically void ab initio, that they were incorrectly issued, contra the Act? Or will the attorneys actually have to bring an application to have that set aside?
Yeah.
So time will tell.
Yeah.
And I think I'll have some discussions with counsel, and we can give some feedback at a later stage about what that process may be. The second one, which I think is relevant to Funda with the dovetail, I mean, the experts.
Yeah.
I mean, as an attorney, what do you expect from an expert, a qualifying expert specifically in terms of future meds?
Well, obviously, from an attorney's perspective, obviously I want the qualifying expert to set out all the future medical expenses in their reports. But I mean, if the fund is in any case going to qualify them or limit them to just injury specific, I mean, it's going to limit myself as well, in some sort of sense. So, but I think also the whole argument between the RAF was to do this to make it administratively easier for them. But I mean, you can't, like I had the discussion with you earlier before, is that you can't make it easy for yourself administratively and think that that's going to trump this legislation.
Correct.
Legislation is clear. It's unconditional. It's just the only conditions, like I said earlier, was the fact that it should have been paid. You should provide proof, and there should be a nexus between the injuries and the accident, as well as the payment that was made for the treatment.
Correct. I think that actually pulled through in the judgment, where that you could pick up that the court said we can't condone.
Yeah.
Obviously I'm paraphrasing, and it's using our own words, but it's to get the point across, is that you can't condone the administrative inefficiencies that you have as the applicant, or the respondent in this case, the Road Accident Fund, by trying to introduce this. It doesn't work, because the technical difficulty is this. What they're saying is, we issue the undertaking. 10 years from now, the client comes back or the patient comes back and wants to obviously claim under the undertaking. We have no idea. They're saying we have no idea whether this is accident related or not. Well, whose problem is that? That's their problem, and it's administratively, because remember, they were issued, all the medical legal reports were served on them. So they've got all of them. They issued the undertaking in terms of that, and they settled the matter. So the fund must be in possession of those reports. So it's as simple as if you receive an account through your undertakings department, they have access to that matter. They look at the reports and they just have a look, is it accident related? In fact, I have it on good authority, to activate that undertaking, there has to be a further letter, a corresponding letter from a doctor. So let's say I were to use that undertaking. I would have to activate that undertaking by having a completely neutral doctor, from what I understand, draft a letter to confirm the treatment at the time of the accident based on my accident-related injuries, the treatment I'm receiving now that I'm claiming under the undertaking, that there's a causal link, there's a nexus between the two. And if you don't have that, they don't activate the undertaking. So I think, you know, the checks and balances are in place, and I think it's important that everyone realizes your primary reason for doing a road accident fund claim is to ensure, I'm speaking from our perspective as attorneys now, is to ensure that the client has that coverage in the future. Getting the money is one thing, but if that person needs a knee replacement or they need a hip replacement in the future, they become a burden on the state, right, if they don't have that undertaking. So that, and then it's government hospital. Now suddenly if they have that undertaking, as they age and osteoarthritis kicks in or whatever, they need that replacement, they have that coverage. It's almost essentially like having a medical aid in the future.
And I mean, obviously the other thing that also is that negatively affects the claimant is the fact that obviously if the road accident fund comes and they limit the undertaking or they put conditions on the undertaking, what's going to happen is, for instance, an occupational therapist might say that, listen, you might need 6 or 7 additional sessions.
Right.
Now, as the claimant, I go for my 6 or 7 additional sessions, but I'm not healed yet. I don't feel better yet. So what's the effect on that? I'm limited. I can't go for any further assessments, so I'm going to have to pay for that out of my own account, which is not fair.
Absolutely unconstitutional, as the court has found, and I think it's important that we as attorneys and as Funda Medical embrace this, and we make sure that the quality of the reports that are going out in terms of the coverage for the future medical expenses, especially if that's going to be related back, make sure that everything is catered for in there, you know, so that if that patient in 5-6 years from now requires the treatment, there isn't going to be a problem. But hang on, it's nowhere, it's not contained in any of the qualifying reports. So where did this, was there sort of an intervening event? Was there something that happened post your accident that you're now trying to claim from the RAF from RAF 4? So I think it's just as a final point, it's quite interesting that the Road Accident Fund has laboured the point over the last couple of years that they are a social benefit scheme. Yet this entire premise that this is based on this judgment is based on the CATS matter, and which is an insurance law matter. So it's an insurance principle, you know, and so maybe that will sort of get them to realize as well now that they keep belabouring this point, but they are actually an insurer.
I mean, you're basically going from your own argument if you're actually using insurance law as your authority.
Exactly right.
So it's it shows that obviously it's not.
Excellent. Thanks, Maurne. It's been great catching up, and we'll do more of these as the judgments come out. As everybody knows, we have the upcoming 3 very important groundbreaking cases on the 16th. Just get the dates right. 16th, Monday the 16th, and Tuesday the 17th of February. They were supposed to be. They're being heard at the SCA. We've heard now, due to security upgrades, they will be heard online. So there's no in situ hearing. But the Monday the 16th, 2 matters on the roll, very important. The Madao judgment, which is the foreigner matter, which affects a lot of attorneys out there. And the second one is the Discovery Health matter, the past medical expenses matter. Tuesday, in my opinion, is the most important since the changing of the legislation in 2008. The most important. I think you were still in primary school then, Maurne, still a young gun. So the Lodgement Directive matter, the LPIF matter, consolidated with the Mautla matter in terms of this very unlawful and cumbersome Lodgement Directive at the moment, where everybody's only getting ML numbers. That's being heard on the Tuesday. So as and when that happens, we'll do a similar podcast, and we'll give the guys some feedback, keep them in the loop, and just a service that Funda Medical provides, and keeping all the attorneys and the experts in the loop. Great.
100%.
Good day.
Thanks, Gavin.